kanalen. I dag skal vi ta opp nok et interessant tema, så jeg setter over til studio.
Then I would like to welcome you to another broadcast here in the Family Channel. My name is Rune Fardal. In June this summer, 16 new child welfare cases were communicated here in the European Court of Human Rights against Norway. We talk about the famous Barnevernet, the Norwegian CPS. Previously, there were already 10 cases against the Norwegian Barnevernet. Of these 10, 3 are settled and Norway was convicted in one of them, the so-called Jansen case. The fact that 16 new cases have been communicated means that the parties are given the opportunity to comment. But this also has another dimension, for Norway is a small country with few people. When so many cases are raised against one government agency in a small country, there is a clear signal that something is terribly wrong with Barnevernet and its responsible leaders in Norway. Common to these cases is that the case cannot be decided until Grand Chamber has handed down a judgment in the Strand-Lobben case. And that is going to take place here at European Court of Human Rights at 10th December next week. On Monday, the last 16 communicated cases were published in HUDOC, the database for European Court of Human Rights. Some of them are about forced adoption, while most are complaints about the extent of permissible contact between children and parents. It's about Article 8 in the Convention of Human Rights. The parties have been given a deadline until the end of September to comment on the last 16 cases that have been communicated. That means the Lobben case will be decided before that. Common to these cases is that the complaints cite breach of Article 8 of the European Court of Human Rights on the right to family life. In addition, in some of the cases, there was also a violation of Article 6 on the right to a fair trial, and in one case, Article 9 on religious freedom. All these 16 cases has been communicated to the parties with questions regarding the parties' view on the case in light of the convention. Now let's take a look at these 16 cases. This is the first one. It is AL and others against Norway. The applicants are a girl, her parents, and her grandmother. In domestic proceedings, it was decided that the girl be placed in foster care, that her whereabouts were not to be disclosed, and that her parents be granted contact rights of 1 hour, 3 times yearly under the supervision of the Child Welfare Services. And then follow the question to the parties. Now, let's look at the next one. This is the second one. It's CE against Norway. The applicant's child, a girl, had been placed in public care in 2012. In 2014, the applicant instituted proceedings to have the care order lifted. Her claim was unsuccessful because, among other things, the authorities considered that the girl would suffer serious harm were she removed from her foster home. In 2016, the applicant anew instituted proceedings to have the care order lifted. And then comes the questions again to the parties. This is the third case. DR against Norway. The application concerns a decision to refuse the applicant contact rights in respect of 2 of her children and to limit her contact rights in respect of a 3rd child that are in foster care. The applicant complains under Article 8 of the Convention that the above entailed an unnecessary interference with her right to private life. And then again come the questions to the parties. This is the 4th case. EM and others against Norway. The application concerns proceedings in which a care order for 2 children was upheld. Contact rights for the mother were refused, and the latter's parental responsibilities for one of the children were withdrawn. The participants complained that the above entailed an unnecessary interference with their right to respect for family life under Article 8 of the Convention. This is the 5th case, EM and TA against Norway. The application concerned proceedings in which the domestic authorities refused to lift the care order for the applicant's child and awarded the applicant's contact rights of 4 hours 3 times yearly. Under Article 8 of the Convention, the applicants submit that the above entailed disproportionate interference with their right to respect for family life. This is the 6th case, FZ against Norway. The application concerns the domestic authorities' decision to authorize the adoption of the applicant's son by his foster mother. Under Article 8 of the Convention, the applicant complains of a violation of his right to respect for his family life. And then the 7th case, KA and AK against Norway. The application concerns a decision to place the applicant's daughter in foster care and limit their right to visit their daughter to 1 hour 4 times per year. Under Article 8 of the Convention, the applicants complain of a violation of their rights to respect for their family life. This is the 8th case, KF and AF against Norway. The application concerns the domestic authorities' decision to remove their parental responsibilities in respect to their daughter X, authorize that X be adopted by her foster parents, and rule out further contact between the applicants and X. Under Article 8, the applicants complain of a violation of their right to respect for their family life. This is the 9th case, MA and MA against Norway. The application concerns a decision to remove the applicant's parental responsibilities in respect of their son X and to authorize that X be adopted by his foster parents. Under Article 8 of the Convention, the applicants submit that the decision to authorize the adoption of their son violated their right to respect for their family life. Under Article 9, they maintain that the decision violated their right to freedom of religion. In the 10th case, MF against Norway, the application concerned a decision to place the applicant's daughter in foster care and limit the right to visit her daughter to 2 hours 3 times yearly. Under Article 8 of the Convention, the applicant complains of a violation of her right to respect for her family life. In the 11th case, ML against Norway, the application concerns a decision in which the foster parents of the applicant's daughter were authorized to adopt the child. Under Article 8 of the Convention, the applicant submits that the above decision violated her right to respect for family life. And in the 12th case, OS against Norway, the application concerned domestic proceedings in which the applicant two daughters were placed in public care and the applicant was granted contact rights of 4 hours 4 times per year. The applicant complains under Article 8 of the Convention that the above entailed an unnecessary interference with her right to respect for family life. The 13th case, RO against Norway. The application concerned a decision to place the applicant's son in foster care and limit her right to contact with her son to 2 hours 6 times yearly. Under Article 8 of the Convention, the applicant submits that the above entailed a violation of her right to respect for private life. The 14th case, SA against Norway. The application concerned the domestic authorities' decision to restrict the applicant's right to contact with 2 of his children that are in foster care to once yearly for 3 hours. The applicant submits that the above entails an unnecessary interference with his right to respect for family life under Article 8 of the Convention. And 15, SE and others against Norway. The application concerns a decision that the municipality take a child into local authority care, withdraw the parents' parental responsibilities for the child, and authorize that the child be adopted by his foster parents. Under Article 8 of the Convention, the applicants maintain that the above entailed disproportionate interference with their right to respect for family life. And in the last, the 16th case, SS and JH against Norway. The application concerned the domestic authorities' decision to remove the first applicant's parental responsibilities in respect of her son, who is the second applicant, and authorize that the second applicant be adopted by his foster parents, and rule out further contact between the applicants. Under Article 8 of the Convention, the applicants complain of a violation of their right to respect for their family life. In addition to these 16 cases, there are 10 other cases as mentioned. Of these, 3 have been settled where Norway lost in one of them. One of the 7 remaining cases is the Lobben case, which will be announced on September 10th. It will be decisive for almost all the other cases because most of these cases are about Article 8 of the Convention of Human Rights. And that convention reads as follows. Article 8 of the Convention, right to respect for private and family life. 1. Everyone has the right to respect for his private and family life, his home and his correspondence. 2. There shall be no interference by a public authority with the exercise of this right except such as in accordance with the law and is necessary in a democratic society, in the interest of national security, public safety, or the economic well-being of the country, and for prevention of disorder or crime, for the protection of health or morals, or for the protection of the rights and freedom of others. Jansen, Lobben, Ensby, Maxine, and Synnes cases are 5 of the total 26 cases that the European Court of Human Rights has communicated to Norway in connection with Norway's child welfare system, the so-called Barnevernet. In the Jansen case, Norway is already unanimously convicted of violating the European Court of Human Rights, Article 8. Judgment in the Lobben case will be published on Tuesday 10th of September this year. What do these 5 cases all have in common? They have all been dismissed in the Supreme Court, and the Supreme Court Judge Bergljot Webster has participated in all of them. I hope this was informative and that you now have a perspective on the cases pending for the European Court of Human Rights in Strasbourg. The Norwegian barnevernet and the responsible authorities has inflicted so much pain, trauma and death among so many children and families that we can only hope that the ECHR now makes a solid statement that can end this abuse of power and crime against humanity that has been taking place for too many years in Norway. Let's all hope that Lobben win against Norway on September the 10th. Otherwise, ECHR will lose all credibility. People will lose hope, and I think that can be dangerous. There is an underlying frustration and anger in a large part of the Norwegian population and among people in several European countries and countries in other parts of the world. The miscarriage of justice that has been taking place in several decades has to stop, and the people responsible brought to justice. Well, that was all from us now. Thank you for watching, and please support the work of Family Channel so we can get all the information out to you. Information on how to support will follow after the program. Thank you for now, and let's hope children and families are heard in September the 10th, and that Lobben gets her son back where he belongs, in his family.